Hello, my name's Tim, and I'm going to take you down a rabbit hole to get lost in the law. Today, we're looking at a decision from the Supreme Court of Canada regarding the Impact Assessment Act, and nicknamed the No More Pipelines Act by its opponents. This is a federal regulation brought in by the Justin Trudeau Liberal government to modernize and standardize Canada's environmental assessment legislation. The reason it's nicknamed the No More Pipelines Act is because it is quite the legislation. Many of the factors considered are interesting, to say the least. One of the things that this act has to take into consideration is both upstream and downstream emissions, which means the emissions of greenhouse gases, in particular, of course, carbon dioxide emissions, which are heavily penalized in Canada with the carbon tax. These laws, or this regime, the Impact Assessment Act, is considered to have been quite far-reaching, and was Trudeau's sort of kind of sledgehammer he brought down on provinces that were trying to build projects entirely within their own provincial boundary, which are normally provincial jurisdiction. Trudeau wanted to use environmental protection legislation in order to elbow his way into the decision-making process of these projects. If you Google No More Pipelines Act, you will see reference from the conservative side of Canadian politics all over the place, from provincial premiers up to the federal Conservative Party. This law was brought in with a lot of opposition from Western Canada. The reason being is that Western Canada's primary resources are non-renewable, and they tend to be emission-heavy projects. Renewable projects are treated much differently in Canada. They have their own set of regulatory regime. It's been in place for many years and untouched in its current form for decades. This applies to things like constructing new dams for hydrogeneration, or forestry processing, things of that nature. The Impact Assessment Act was challenged in our Provincial Court of Appeal, the Alberta Provincial Court of Appeal, as being unconstitutional. And the way that something is unconstitutional in Canada, one of the ways that it can be ruled unconstitutional is that it exceeds parliamentary authority. My American audience will recognize the sort of language around that. Oftentimes, Supreme Court decisions in the United States are brought regarding questions of whether a state or the federal government has jurisdiction to legislate over a certain topic. We saw that in the overturning of the Roe v. Wade. You'll also find that Supreme Court cases tend to challenge the power of the executive in the United States versus the legislative power. So there are things like, for example, Obamacare was challenged as being, actually, that's not a good example. Certainly, Trump's executive order around immigration was challenged as exceeding his executive authority and subverting Congress. So, regardless of the ruling of any of those cases in the United States, that's just sort of the parlance that we use here in Canada, is when something is outside of the jurisdiction of the federal government, it usually relates to matters that are entirely within the jurisdiction of provincial government. And so a law enacted by the federal government that inappropriately tramples on the provincial government's area of power is ruled to be unconstitutional and of no effect. to the extent that it is incompatible with the provincial legislature. So that's the kind of parlance that the Supreme Court uses. They ultimately came down on the side of the provinces, saying that the Impact Assessment Act is unconstitutional for being ultra vires of Parliament. That is, outside of its power. It's outside of the jurisdiction of federal Parliament. Remember, this was a law brought in by Justin Trudeau, so it's a federal government act. You can see that all of the origin of the case is the Attorney General, which, again, my American audience will recognize these types of terms. The Attorney General for Canada is our Justice Minister. So, unlike the U.S., our heads of the executive, or the executive branch of government, are all parliamentarians. They sit in our legislature. The cabinet minister of justice is the head of that executive branch and also a legislator. In this case, the minister of the Department of Justice is also the Attorney General. And that applies to both the federal government and the provinces. Both of them have the same position. And so this is the Attorney General of Canada and the Attorney General of Alberta going up against this Impact Assessment Act. You can see a lot of interveners in this case. And it means the same thing as in the U.S. Interveners are people who are said to have an interest in the outcome of the case, and are therefore, with leave of the court, allowed to make submissions to that effect on how the case will affect them and why the Supreme Court should consider their interests when they make the final decision. You can see all of the provinces are represented, right? We're missing a couple. I don't see Nova Scotia, Prince Edward Island, or oh no, there's New Brunswick. Yeah, Nova Scotia and Prince Edward Island. And of course, the territories, while they have a government that runs them, the three territories of Canada are federal-ish. I don't think they are allowed to intervene in this case. Regardless, they didn't so, unless they appear further down in the list. You can see plenty of First Nations representation here. Also an intervener, the Canadian Association of Petroleum Producers, which is one of the largest advocacy groups for oil and gas exploration here in Canada. Well, petroleum implies just oil, but oil and gas are typically seen as similar enough industries that they can advocate for one another. Many of the major companies in Canada that provide petroleum resources also expand into the area of natural gas. So, oil and gas are typically kind of bundled together. Even though they are distinct industries, they have a lot of similarities to one. Enough that an advocate for one is often an advocate for the other. The Canadian Taxpayers Federation, which was an interesting intervener. But then you see these Eco Justice Canada Society. Hydro-Quebec was an intervener. The Canadian Constitution Foundation. Look at all of these interveners here. The Ocean's North Conservation Society. You can see a lot of these environmental Lumi Nation. That's a First Nation. So these nations, you can see these nations here, right? They're indigenous people organized into federal nations. They have special constitutional protection, special recognition in our Constitution. Not unlike the U.S., treaty lands are considered they're considered kind of their own thing in American law, and so I would say they have more independence in the U.S. than they do in Canada, but regardless, most of them are interveners here too, because this legislation had a huge impact on their rights. Advocates for the rule of law. You would think that people who oppose the mandate of this organization would be quite few. You know, maybe King Charles opposes the advocates for the rule of law, but that's about it. But anyways, I actually don't know anything. Some of these I'm hearing for the first time. Like I know of others. I know of the independent contractors business, the Alberta Enterprise Group. Like I'm familiar with many of these. This is interesting. The Canadian Association of Physicians for the Environment. Um, I'm aware of a few of these environmental organizations too, especially environmental defense. I saw another one. There's WWF, World Wildlife Fund. Ducks Unlimited is not one. That's surprising. Athabasca Chippewa First Nation is an interesting one. They're located entirely, or I guess adjacent to the Athabasca oil sands, which is one of the largest reserves of oil in this country. In fact, in the world, I think it's like top 5 reserves of oil in the world, maybe top 10. But this is the First Nation that is located the closest to that deposit, and the mining companies that explore and mine the oil up there, they employ a significant number of people in that First Nation. For better or for worse, the mining companies have made this place very wealthy, very wealthy, which has been it's been a boon for the people who live there. That having stable employment and a booming economy tends to do well for covering up social problems on our reserves. If you're a regular on this channel, you've heard me talk about the conditions on uh, First Nations reserves for many years. But this is one of the few that actually it's a pretty good place to go, to live, to work, to raise a family. They have drugs and alcohol and gang problems just like any other First Nation reserve, but you'll find that for the most part the reservation maintain a very good quality of life. Same cannot always be said for these other reserves that are sprinkled through this intervener list. So of course their interests, and I don't even know what side they took, and we're not going through the submissions. We're actually going through the final. Some other time I can go through this arguments. Um, See what side of the aisle they kind of came down upon, or even that maybe they didn't take a side. They just said you could absolutely go in there and be neutral as to the question, but still say these are the rights that I want you to consider and take into account when you make your decision. Then that's perfectly acceptable too. So enough with the introduction. Let's get into why we're here. So the first thing we're going to do is go through what the Supreme Court said. And so the way that this is all laid out, of course, this was when the arguments were made. So I'd have to go back to those dates to see the oral submissions from the litigants in this case. And then this is the date the decision was released. See, it was actually quite recently. I'm just getting around to it now. These are our Supreme Court judges that were present and heard the case. This case originated on appeal from the Court of Appeal of Alberta. Alberta doesn't have a Supreme Court. Those familiar with cases out of New York State will know that there is a such thing as a New York Supreme Court. I think a few states, I can't remember which ones, use that parlance. British Columbia has that. There is the British Columbia Supreme Court. That is the highest trial court of a jurisdiction. Ontario has what's called the Superior Court of Ontario. That equivalent court would be the Court of King's Bench in Alberta. We don't have a Supreme Court of Alberta. It's the Court of King's Bench. And then we have the Alberta Court of Appeals, and every province also has their own respective court of appeals. So the British Columbia Supreme Court is actually just the highest trial court in British Columbia, and then there is a British Columbia Court of Appeals, and then you go to Supreme Court of Canada. So the naming can sometimes be confusing, but in Alberta it's much more straightforward. It's the Court of King's Bench now, with the passing of our beloved Queen. But and then this heading is just kind of how it's organized. Supreme Court decisions are public domain; they are released to the public. So this is kind of how it's categorized when you're trying to search for it later. These just simply refer to the laws that were the laws and the regulations that considered in this question. This is a case brief that the Supreme Court prepares, so it's a great way to just kind of get the meat of the we'll read it in a second, but it's just a good way to get the meat of the decision. These are the judges that take the position of the majority, and then these are the judges that dissent, or they disagree with the majority. And of course, this is the ruling. The appeal should be allowed in part. So we'll go through what that means in a second. But this briefing of the few paragraphs of the briefing above is a summary of this much. And I'll scroll through just to see how much is here. There's a lot. There's a lot here. Still going. So we're not going through all of this. You can go read the decision for yourself. I'll try to remember to link it in video when I release it. But still going. Finally, we're at the bottom. Oh boy. That's the conclusion. Spoiler alert. Oh, sorry, no, this is the conclusion of the dissent. Anyways, yeah, huge decision of. That's why the Supreme Court took so long to render this. They had to write all this stuff. Anyways, we're just gonna stick with the briefs because they accurately will summarize that entirety of that 300 whatever plus paragraphs of info that they had. If when you're a law student, these briefs, sometimes they don't tell you why they came to a certain decision. They'll just tell you that a decision rendered on this, and we find that this, precondition exists, and therefore we're going to make this ruling. When you go to cite a case like this on an exam, you better have read the 300 plus paragraphs underneath it, because you need to know exactly what you're citing, what the court found, what it ruled on, and how you're applying it to your problem when you write any exam in a law course. The same with practice too. Citing to the brief when you, when you're doing when you're doing an authority, when you're citing an authority, because of course this is a Supreme Court ruling. We have the same jurisprudence that the U.S. has, so the Supreme Court binds the other courts. This when you cite to this authority, you cannot cite to this brief when you're practicing law, like if you're making constitutional challenges to laws of Parliament, you can't cite to the briefing here. You actually have to go down to the paragraph and cite to those paragraphs. So you can see that there is a sort of there's a short history here. This is an explanation of what the law does. There's a small, because this law was actually broken into two sections, and so there's a second part here for the second part of the law. This is the problem that the, so if you're doing this as an Iraq breakdown, this is the issue, right? And then the majority are going to write their ruling or the rules, right? The division of power analysis. So we'll go and look at Canada's constitution, and I'll show you the division of power provisions. They're not very long, but that's the applying the law portion. So I'm more in Canada. We use FELAC as the acronym, but it means the same thing as Iraq, right? Issue, rules or law, analysis, and conclusion. FELAC is facts, issue, law, analysis. And you'll find that this decision is actually broken down in that same way. It's broken down in a FELAC manner. So, anyways, back up to the top. We'll start at the beginning and get the history of this. And so, in 2019, following a review of the existing federal legislation, Parliament enacted the Impact Assessment Act. There's also accompanying regulations. The court has found that there's essentially two schemes in one. First, a discrete portion of the act contained within these two sections. And we'll look at this law in just a second, but it's a huge law, and I don't think there's a lot of value in... There's not going to be a lot of value in going through the entirety of the act, because as you'll find out later below, what the act says is only a part of the assessment process. Anyways, it deals with projects carried out or financed by federal authorities on federal lands or outside Canada. So the court ruled that that small section was constitutional. The federal government's allowed to legislate to impacts on federal land or outside of Canada. That's entirely their jurisdiction. It's outside of the jurisdiction of provinces, and so the court found that that was constitutional. Second, the balance of the scheme, so the majority of the scheme, is made up of the Impact Assessment Act's remaining provisions and regulations dealing with designated projects. The impact assessment process can be divided into three phases: the planning phase, the impact assessment phase, and the decision-making. The decision-making phase is the one where we run into big issues. I'm going to jump over the other parts. Well, actually, no. The impact assessment phase is the one that kind of catches the unconstitutional portion. So, the agency will consult a number of parties. Here we go. In the impact assessment phase, the owner is required to provide the necessary information or studies to the entity conducting the assessment, which will be the agency which administers this law, act, or its delegate. This phase culminates in the preparation of an assessment report, which sets out the effects that are likely to be caused by the carrying out of the designated project and indicates those that are adverse, effects within federal jurisdiction, and those that are adverse, direct or incidental effects. And those terms are defined in the law itself. The assessment report must also take into account numerous mandatory assessment factors listed in Section 22 of the law. The mandatory factors include changes to the environment or to health, social, and economic conditions, and the positive and negative consequences of these changes. Now, because this is the brief, this is what the court found. Not necessarily does that what the law was intended to do. The court conducted what's called a pith and substance analysis. You'll find that term come up quite often in this document. Pith and substance analyses are an exercise the court does to ensure that it's capturing not only the intended purpose of a law, but also its actual purpose and its unintended effects. Because those matter when you're assessing what a law is designed to do and what it actually does. In the context of ruling something unconstitutional, what a law actually does matters just as much as what it's supposed to do. Finally, during the decision-making phase, the decision-maker must determine whether the adverse effects within federal jurisdiction and the adverse direct or incidental effects are in the public interest. If the decision-maker concludes that the effects in question are in the public interest, the Minister of the Environment must establish any condition that the Minister considers appropriate in relation to those effects. And so this is tied to the Minister of the Environment, which is the federal Minister of the Environment, a member of Justin Trudeau's Liberal cabinet. And when you get to the factors that this law is supposed to consider, you're gonna see, you're gonna see that they stack the deck strongly against projects that promote the exploration and exploitation of fossil fuels. Okay, so again, they ruled that this was constitutional, so I'm just going to jump over that part. That part was not an issue. And of course, the reference question by the Alberta Court of Appeals is whether that law is unconstitutional. All right. Federal Impact Assessment Scheme is unconstitutional in part. Although that separate, the separate process in Section 81A 91, the Constitution separated out, the balance of the scheme, that is the designated projects portion, is ultra vires Parliament. It is outside of Parliament's authority and thus unconstitutional. The designated projects scheme is ultra vires for two overarching reasons. And here you go. It is not in pith and substance directed at regulating effects within federal jurisdiction. So you see right here, oh, sorry, it was above. Right? So the law says, hey, we're only concerned with this. The court conducted a pith and substance analysis and found that it is not within that. It is not in pith and substance directed at regulating effects within federal jurisdiction because these effects do not drive the scheme's decision-making function. So, this quoted term here, effects within federal jurisdiction, which an easy example would be pollution of the waterways. Waterways are, especially even inland waterways, are federal jurisdiction. But even waterways that flow through First Nations reserve, those are absolutely within federal jurisdiction. And so pollution of a waterway that flows through a First Nations reserve would be one of those effects within federal jurisdiction. What the court found, though, is that when you analyze the pith and substance of the law, those effects do not drive the decision-making function. The defined term within effects within federal jurisdiction does not align with federal legislative jurisdiction. The overbreadth, so the Supreme Court's ruling is that this term is too broad. The overbreadth of these effects exacerbates the constitutional frailties of the scheme's decision-making functions. So the Supreme Court is saying that this is on thin ice to begin with, and the fact that this term was left open to interpretation, the court found that it being too broad was the tipping point that made this law unconstitutional. And they decide to throw this in here just to make sure that everyone knows that this law will come back, and it will remain mostly the same as long as it addresses some of the problems that the Supreme Court found with it. Environmental protection remains one of today's most pressing challenges. Excuse me. Oh, goodness. Try to edit that out. Environmental protection remains one of today's most pressing... Really? Oh, my goodness. Environmental protection remains one of today's most pressing challenges. And Parliament has the power to enact a scheme of environmental assessment to meet this challenge. But Parliament also has a duty to act within the enduring division of powers framework laid out in the Constitution. Now the court's going to explain why it found what it did above. The division of power analysis has two steps: characterization and classification. At the characterization step, a court must consider the purpose and effects of the challenged law in order to identify its pith and substance. In order to determine a law's purpose, a court looks to both intrinsic evidence, the text of the law, its preamble, its purpose clause, if it has one, its title, and its overall structure, and the extrinsic evidence, the context of the law in question, the minutes of parliamentary committees, and relevant government publications. In analyzing the effects of the challenge law, a court considers both legal effects, the effects that flow directly from the provisions of the statute itself, and practical effects, the effects that flow from the application of the statute. Finally, the court must characterize the pith and substance of the challenge law as precisely as possible, capturing the law's essential character in terms that are as precise as the law will allow. Characterization is distinct from classification, and it is imperative that the characterization and classification analyses be kept distinct. You see this term coming up again and again, the pith and substance, right? What does the law actually do? Is what its pith and substance is. And the court looks at a lot of things, both internal and external to that law, to arrive at that decision. That's why I caution that reading the text of the law only will take you so far, because the court also used evidence outside the law. Especially this part right here, the context of the law in question. We're looking at both Supreme Courts have both taken judicial notice of the fact that climate change is a pressing matter, and it is within the government's best interest to regulate adverse environmental impacts in order to tackle its obligations in regards to climate change. I don't know if maybe I'm not entirely sure the U.S. Supreme Court has taken judicial notice of that fact. Certainly state courts have, California especially. Definitely the Canadian Supreme Court has taken judicial notice of that fact. You saw it above, right? There was another law that Trudeau brought in, nicknamed the carbon tax. It's called the Greenhouse Gas Polluters Pricing Act. Yeah, I think is what it was called. GGPPA. The official title of the act. That was actually ruled to be constitutional, in part because of a provision of our Constitution that, and it's rarely invoked, but there is a part of the Constitution that has legal consequences, and we'll get to that in a second. First, I think we've seen enough of the... actually, no, I want to show a little bit more about on this decision. But I certainly wanted to make sure that so if I can define what pith and substance really is, it just boils down to what does this law do? All of what it does, as precise as possible. Um, Only after precisely stating the matter to which the law relates should a court proceed to the classification phase of the analysis and consider specific heads of power. That's just presumptive law. That's not. No. Yeah. So the presumption is that Parliament enacts laws that are constitutional. And so if the court is not able to determine, like if it can't come to a conclusion that a law is outside of Parliament's power, then the law shall stand as good law. Because that's the presumption. Of course, and this shouldn't have to be said, but the court says it anyways. The court cannot rely on the presumption of constitutionality to disregard a statute that speaks clearly and is ultra vires of it. You'll see this term come up a lot. That's again, that's what we use to determine. That's our phrase to say that something is outside of Parliament's jurisdiction. And then there's an inverse called intra vires, within Parliament. We will look at this here, sections 91, 92 of the Constitution Act. We'll have a look at those. But yeah, after it's been characterized, it then must be classified. And if it is classified as falling under a head of power assigned to the adopting level of government, the legislation is intra vires and valid. A law is classified based on its main thrust or dominant characteristic, and its secondary effects are not the focus of the validity analysis. The fact that a valid law incidentally touches on a head of power belonging to the other level of government does not affect its validity. So it shows that there is a large hurdle to pass here. The fact that there is these kind of minor side effects that go into provincial jurisdiction, that in and of itself is not enough to say that the law is not good law. That main focus of the law has to clearly intrude on provincial jurisdiction to be found ultra vires as a federal jurisdiction. Classified environmental legislation presents a challenge because the environment is not a head of power. Environmental management cuts across many different areas of constitutional responsibility. Neither level of government has exclusive jurisdiction over the whole of the environment or over environmental assessment. Both levels of government can legislate in respect of certain aspects of environmental protection, including certain aspects of environmental activities. Shared federal and provincial responsibility for environmental impact assessment is neither unusual nor unworkable. Rather, it is a central feature of environmental decision making in Canada. So the fact that it's not classified under either head of the division of powers was it's not an oversight, it was on purpose. The fact that we are the makeup of this country is that we are a confederation. We're supposed to work together under a strong central federal government. Certain things the federal government can do without provincial permission. In fact, it can even impose on provinces. We'll see a couple of examples of that in the Constitution. But there are some things that the founding fathers of Canada said was, we want these two powers to work together on this. Which reflects the idea that actives falling within the federal and provincial. There's some environmental assessment analysis here. I don't think it's not worth going into too deeply for that. So, this is what the court found on the totality of the internal and external evidence through the law itself. The scheme articulates a broad array of purposes, including protecting the environment and fostering sustainability, satisfying Canada's environmental obligations, assessing and regulating the broad effects of certain physical activities such as health, social, and economic conditions, facilitating the participation of Indigenous peoples and the public, and establishing an efficient and transparent process. Whew, that's quite the. But again, in order to be precise, this is what the court has to kind of zero in on. It has to precisely, to the extent the law allows, characterize what its purpose is. So, yeah. The statement here, the pith and substance of the designated projects component, which is the one that was found unconstitutional, is to assess and regulate designated projects with a view of mitigating or preventing their potential adverse environmental, health, social, and economic impacts. Pith and substance of the component. Oh, yeah, that's the. Yeah, so here's the totality of the pith and substance analysis. And honestly, those 300 paragraphs that are way further down, that's most of it deals with the bulk of how the court came to this conclusion, right? So this is the conclusion it came to. The pith and substance is: there is no doubt the Parliament can enact impact assessment legislation that is directed at federal aspects of projects. Breadth of these federal aspects will vary from with the circumstance. Where Parliament is vested with jurisdiction to legislate in respect of a has broad discretion to regulate that activity and its effects, but Parliament's jurisdiction is more restricted where the activity falls outside its legislative competence. In those cases, it can validly legislate only from the perspective of federal aspects of the activity. Designated project scheme treats all designated projects in the same way, regardless of whether Parliament is vested with broad jurisdiction over the activity itself or narrower jurisdiction over the activity's impacts on the federal head of power. So this is why the law was ruled unconstitutional. The court recognized that federal jurisdiction can have two sort of aspects. There's broad jurisdiction where the project happens on federal land, but then there's this narrower jurisdiction where the project has nothing to do with federal land, or federal jurisdiction in this case. Again, the easiest example is First Nations people. They're entirely within federal jurisdiction, and so if you construct a project on First Nations land, that is the broad definition. It is federal jurisdiction, and so it can enact any scheme it wants to regulate that portion. The narrower one is projects constructed upon provincial land that don't have that are part of within provincial legislative authority. And even if it does have a impact on federal land somewhere, an incidental impact, the federal government's power to legislate is not the same in those two circumstances. The law, as it stood, the Impact Assessment Act, didn't distinguish between those two. Therefore, by giving that same weight to something that federal government had only a very limited or narrow jurisdiction to empower, will make the law unconstitutional. And many of the physical activities to which the scheme applies are primarily regulated through the provincial legislature's powers over local works and undertakings or natural resources. We will find this when we go to the Canadian Constitution. We'll find this language there, so that's what the court pulled in. Parliament can enact impact assessment legislation to regulate those projects from a federal perspective, so long as the regulation of the federal aspects represents the dominant characteristic of the law. Well, we found in the pith and substance analysis above that that is not true, right? The pith and substance is potential adverse environmental, health, social, and economic impacts. None of those are federal, specifically federal, right? We just saw the analysis above that environmental is a shared responsibility, health is a provincial responsibility, social and economic impacts are shared responsibilities. Social tends to be provincial, but there are some federal aspects. All of these impacts on federal land exist, but on provincial land, they're provincial authority. Right? So, and what the court is going to end up finding is that when you actually put this law into use and you choose to deny a project, you can do so for any one of the reasons that were listed here, right? Adverse environmental, health, social, and economic impacts. You can deny the project for any one of those reasons. The reasons that, if you cite a reason that's entirely within provincial jurisdiction as a reason to deny the federal government's approval of the project, then that is unconstitutional. And we will find further below that while many things are considered and brought together in the analysis, the law does not direct the decision maker to only use the federal aspects. It assigns equal weight to all factors, including the ones that were outside of its jurisdiction. And so the court concluded that it is possible to reject a project entirely on invalid grounds. That possibility, therefore, renders the law unconstitutional. And here, what I just explained is actually going to be explained right here. I probably should have just read this instead. But yeah, the designated projects ultra vires as its pith and substance exceeds the bounds of federal jurisdiction. This is for two overarching reasons. First, the effects within federal jurisdiction do not drive the scheme's decision-making. Consequently, the scheme is not in pith and substance directed at regulating these effects. There are 4 decision-making junctures embedded in the scheme. The scheme requires the decision maker to consider a host of factors, but does not specify how those factors are to drive the ultimate conclusion. The scheme's decision-making mechanism thereby loses its focus on regulating federal impacts. Instead, it grants the decision maker a practically untrammeled power to regulate projects quora? Not before. I believe that just means projects as projects. I don't know why the Latin was. Anyway, that really tripped me up. I have to brush up on my Latin, which they don't teach you in law school. They don't teach you Latin. They do teach you Latin terms. This is not one I've come across yet. But yeah, if I were just to translate this, it grants the decision maker a practically untrammeled power to regulate projects as just projects. Rather, in order to be constitutional, it has to regulate projects as impacting federal jurisdiction, and it can only regulate to that extent. And so, of course, the law in its current written form is not that. It regulates the projects in its totality or entirety, regardless of whether Parliament has jurisdiction to regulate a given physical activity in its entirety. What I just said. In this respect, the screening decision and the public interest decision are constitutionally problematic. Screening decision as to whether an impact assessment is required for a particular project must be rooted in the possibility of adverse federal effects. However, because the decision maker must take into account an open-ended list of factors, all of seemingly equal importance, only 2 of them tied to federal jurisdiction, an impact assessment could be required for reasons other than or not sufficiently tied to the project's possible impacts on areas of federal jurisdiction. Similarly, The public interest decision must focus on the project's federal effects. However, because of the mandatory public interest factors are not all confined to the federal legislative competence, and because some factors are framed in relation to the assessment of the project as a whole, rather than to the adverse effects within federal jurisdiction, a determination of whether adverse federal effects are in the public interest is transformed into a determination of whether the project as a whole is in the public interest. Okay, so that's quite a sentence. Sure, that's a run-on sentence too. So let's break the sentence down. The mandatory public interest factors are not all confined to federal legislative competence. Right? We went through the list. They're not solely federal jurisdiction. And because some factors are framed in relation to the assessment of the project as a whole, right? Again, the pith and substance was that this applies to the project as a whole rather than narrowly restricting to the effect within federal jurisdiction. We also find out that this quoted. There's a reason why this has been quoted. This term has been put into quotation marks. We're getting to that in the next paragraph. And so, because there's no narrowing of that focus, it is transformed into a determination of whether the project as a whole is in, rather than assessing whether the project is in the federal interest, that is a completely different analysis, right? Second, the defined term effects within federal jurisdiction does not align with federal legislative Section 91, but goes far beyond its limit. Its overbreadth manifests itself in two distinct ways. So it's saying that this is why it's been double quoted this entire time. This term is too broad. First, the definition of effects within federal jurisdiction is central to the scheme's decision-making functions. Its overbreadth dilutes the focus at the key decision-making junctures, shifting it away from federal aspects and encompassing aspects that are within. Second, the defined effects within federal jurisdiction result in impermissibly broad prohibition. Due to the overbreadth of these defined effects, conduct prohibited by Section 7 of the Impact Assessment Act extends beyond the range of conduct that Parliament can validly regulate pursuant to its assigned heads of power. Whew, that was something. Okay, and the dissent here is that they disagree and say, oh yeah, it's within. And these two dissenting judges will go on the part of saying that the environment is king. Sometimes it is interesting to go into the dissent because you can find things that you can use to argue later in other court cases. I mean, arguing the dissent of a Supreme Court decision is not always a good idea, but there are certain circumstances that bringing it in can help make your case, especially if the judge characterizes something in a way that the other judges did not consider. Sometimes, especially when it comes to the Supreme Court, they will come up with a test to determine if whatever you're doing is allowed. The test that the majority comes up with will often end the analysis whenever you meet that test, and so the court will not proceed with the analysis of items further down in the test. The dissent will maybe disagree that the item met that first branch of the test and then go into the analysis of the second branch of the test. And that's not what the majority went into in their decision. So there are some times where the dissent will analyze things in a way that is helpful to you, lawyer, but you should always be cautious when you cite to the dissent of a decision, and if you cite to it as an authority to help build your case, you better be damn sure you point to exactly what you're citing to and why you're citing to it. Because if you're citing to something that the minority found that was overruled by the majority, it's not going to be very strong. So, I didn't actually get a chance to pre-read the dissent. Oh, so they differed in the pith and substance analysis. Hmm. So this actually this lists the federal government's head of powers that apply to this legislation. Again, the dissent can be useful in some ways. Um I like that it has a provided that it is anchored. So what it's saying is that the law itself is constitutional. Its application may be unconstitutional, and so the dissenting minority of the Supreme Court is saying that as long as you remain within this part of the law, then you're within the Constitution. Um, and it gives you right fisheries, navigable waters, Indians, and lands reserved for Indians, criminal law, international and interprovincial rivers, and the national concern branch of the peace order and good government power. This is a rarely invoked, but it's a very powerful part. Um, the Supreme Court has used the national concern branch analysis for many of the laws that they're impacting things that were, oh, how do I put it, not considered or not covered by the founding fathers. So you sometimes see this argument come up in Second Amendment American um, legal arguments, right? The Second Amendment was never intended to apply to assault rifles. That's a flawed. I think that's flawed, but whatever. Um, that is the argument they make, and we have a similar argument here in Canada. The founding fathers never foresaw the rise of technology, the fact that our industrial processes would have the impact that it has had on the environment. And so, within their infinite wisdom, the founding fathers left a small nugget in our Constitution that allows you to bring a matter of national concern into the federal government's power, even if it was not already designated as being within federal government authority. So, yeah, see, sometimes reading a dissent yields you some interesting things. This is the law, the Impact Assessment Act. So I wanted to focus on these factors to be considered. And we'll just have a look at all of the things that they had to consider. And you're going to see the ones that are, just keep this in mind when I get to the Canadian Constitution and we look at the heads of power. But you saw that, let me go back. You saw the list right here. So if you can just keep right, fisheries, navigable waters, that is like our major lakes, our major lakes and rivers, our navigable waters, small creeks and swamps are not. Indians and the lands reserved for Indians, obviously. Criminal law, which is different from the U.S. In Canada, federal law, the power to regulate criminal conduct is a federal jurisdiction. Rivers that flow in between provinces or over the international boundary, and of course that POG branch, called as POG, right? Peace, order, and good government. Called POG. So let's remember that list for when we get into this. So the impact assessment of a designated project must take into account the following factors: changes to environment or to health, social, and economic conditions, positive and negative consequences, changes that are likely to be caused by carrying out the designated project, including the effects of malfunctions or accidents that may occur in connection with a designated project, totally outside of federal jurisdiction. That is employment and labor standards, right? OSHA. That is provincial jurisdiction in Canada. You cannot Oh boy, and that is good law for over 150 years. Um, so I mean, the first one immediately just steps on a landmine, right? Any cumulative effects that are likely to result from designated project in combination with other physical activities that have been or will be carried out. This is a whole lot of words that don't really mean a bunch, but I think what they're going for is two projects together. And while the net effect of both together cannot be isolated to either or, the totality can be considered and the result of any interaction between effects. Uh, Anyways, mitigation measures that are technically and economically feasible and that would mitigate any adverse effects of the designated project. Also out of jurisdiction. That is a regulation of industry. That is provincial jurisdiction. The impact of the designated project may have on an indigenous group. That is in jurisdiction. All indigenous relations are matters of the federal government. The purpose of and a need for the designated project, I mean, makes sense. Also out of jurisdiction. The federal government doesn't regulate the purpose or need of projects. That is, again, that's industrial regulation. That's provincial jurisdiction. Alternative means of carrying out the designated project that are technically, economically through the use of best available technology and the effects of those means. Also out of jurisdiction. Any alternatives to the designated project that are technically okay. So all three of those are out of jurisdiction. Indigenous knowledge provided with respect to the, okay. Again, one of those things that means nothing. I think it is in jurisdiction. The extent of which designated project contributes to sustainability. You might be able to argue that under the POG power, but that's going to be a tough argument because it is a designated head of provincial jurisdiction. The extent to which the effects of this is why it was called the No More Pipelines Act. This factor right here, the extent to which the effects of the designated project hinder or contribute to the Government of Canada's ability to meet its environmental obligations and its commitment in respect of climate change. But it doesn't mean anything in the law, and it's also out of jurisdiction. The Government of Canada can regulate to the extent that it tackles climate change. How do I word this? No, actually, I think that might be allowed under the POG power. That's one that has been uncontested because the rest of the act was ruled unconstitutional. I bet if you hear during oral submissions, the federal government's the attorney general for the lawyer representing the attorney general of the federal government probably based a lot of its argument on POG when with regards to this section. That's going to be an iffy one. Any change to the designated project that may be caused by the environment. Okay, environmental regulation in and of itself, again, is a shared responsibility, so the government doesn't get to exercise exclusive jurisdiction. I think that would be the counter argument to this one, which is why the Supreme Court said that only two of those fell under solely under federal jurisdiction. Because I think you could argue that this is also a provincial jurisdiction. It's that shared, right? The Supreme Court said that that's a shared responsibility between the province and the federal government. So that would be the counter argument, right? POG is obviously the issue of climate change, but the greater regulation of environmental obligations is a shared responsibility. So because that's up in the air, I don't think that's considered one of the valid exercises of the head of power. The requirements of a follow-up program, also out of jurisdiction. Considerations related to indigenous cultures raised with respect to the designated project. I think this is the second one because this one doesn't really mean anything. And actually I can almost consider that these two are like one and the same. Probably just combine them and change the meaning of the law. Community knowledge, that is absolutely, and you'll see why in just a second here, absolutely outside of federal jurisdiction. Comments received from the public, out of jurisdiction. Comments from a jurisdiction that are received in the course of consult. Okay. Oh, yeah, that's the federal, outside of Canada branch. Any relevant assessments outside of Canada. Any assessment of the effects of the designated project, again, means nothing. If you do read the 300 plus paragraphs, I think they break down each one of these, and they may say that, well, we'll just combine this. This is the most hilarious one when the law was released and people read it. The intersection of sex and gender with other identity factors should be taken. The impact assessment of a designated project, whether it is conducted by the agency or a review panel, must take into account the following factors: intersection of sex and gender with other identity factors. This is why this law was mocked so much when it was signed into power. But, you know, massive oil project denied, women most affected. Oh, God. Just on its face, right? On its face, that wording is such a problem. Why couldn't it have just been equity? Why couldn't you have just said that the application of equity doctrine? Why did they have to call that out? And maybe I'll make another video about this, but I'd actually like to see how the Supreme Court interpreted this in the pith and substance analysis, or if they just jumped over it because they're like, yeah, that's just political fluff. And then, of course, it's open-ended. Court said it's open-ended, and this is the thing. Makes it open-ended. Any other way. Now, important note about this, just because you put this into a law doesn't mean that you can consider things that are not allowed to be considered. So when you say any other matter relevant to the impact assessment, our jurisprudence says that when you, any matter that you file or characterize under this subsection T, it has to be reasonable, and it has to be still within the power of the law and framework itself. So, just because it's open-ended doesn't mean that you can go off the board and just consider anything. You have to consider things that relate to this administrative scope, and you have to, you can only consider things that are reasonable to consider, that can be tied back to an impact on the project itself. So, what you wouldn't be able to consider is the destruction of the the Great Barrier Reef, right? The bleaching of the Great Barrier Reef cannot be a consideration under subsection T. It's not reasonable to something to tie impact to something so far away. There's nothing else here that I think going through. All right, distribution of the legislative powers. This is what the Supreme Court referred to, Section 91 of the Constitution Act. This is the Canadian Constitution. We're at Section 91. It is lawful. It shall be lawful for the Queen, rip, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada. That is the POG power right there. Rarely used, but it's, if something doesn't fall into any of these lists, and it is a matter of national concern, or even if it does fall in the list, but that its importance is suddenly elevated into a matter of national concern, such as an emergency. Oh, you mean like COVID-19, because healthcare is typically provincial jurisdiction? Yeah, exactly like that. um, the POG power is really strong, but it's hard to get into that national concern branch. There is a test related to that. Since that was not applied to this ruling, I'm not going to go into a POG analysis, but it is an interesting case study. You'll my Constitution textbook here covers it quite well. Um, maybe someday I'll go into a POG analysis, but yeah, and you'll notice that the Constitution textbook been joined by a couple of other textbooks that I found in storage. Wish this would stand up correctly. And but that is my undergrad in computer science. I have a couple of my comp sci books here. Anyways, these regulate the areas that the federal government is allowed to legislate in. You're gonna see, you know, beacons, buoys, lighthouses, and Sable Island. I like that it's specifically just one island. Navigation and shipping, that's pretty easy to say. Sea coast and inland fisheries, you saw that in the list in the consent. Also the Postal Service, just like the US. Census, military and defense, our unemployment insurance program, regulation of trade and commerce. This is actually on its face, it may seem like just about any resource project can be fit into the regulation of trade and commerce. It's actually a very narrow power that the court has ruled upon. If you read, we don't have like the Federalist Papers like the US does, but we do have some, you know, there are resources that you can use to kind of read like what the founding fathers meant by some of these terms. And when you go and read that, you'll find that the regulation, trade, and commerce was actually supposed to be very narrow and apply to only limited subjects. And so you don't see this come up very often. It's not in our case law very often because it's considered to just be good law that it's narrow. So it's really hard to argue to add something under this clause. Of course, the borrowing of money on public credit, right? Our debt, raising of money, mode or system taxation, currency and coinage, banking. This is the reason why we use the imperial system now. No, sorry, the metric system. It's in federal government's power to change. We actually changed from imperial to metric. I don't remember what year it was. I think 80s. But we actually changed from the U.S. measurement system to metric. We went from freedom units to scientific units. As I just smile smugly at the shot at the U.S. It actually caused a problem. There's a case of a Canadian airline that was trying to convert, because everyone up until that point used the imperial system. And in fact, you'll find a boomer generation in Canada, they still will, they'll say temperature in Fahrenheit. It is common for Canadians to measure things in feet and miles, like, oh, you're about a quarter mile down the road. None of our signs measure that, right? It's all in kilometers. You'll find a lot of older Canadians are still used to feet, miles, inches. A lot of our industry still uses a micrometer that measures like fractions of an inch, or thousandths of an inch. So even though it's called micrometer, that's weird. Yeah, you'll still see that in industry, quite common. So there, that disconnect is odd, and it can be a problem. There is an airline that tried to convert, it was trying to convert the gallons of jet fuel into metric weight of jet fuel, because the truck pumps in gallons, but the airplane's internal computer measured fuel in kilograms. So when they tried to do the calculation to figure out how much fuel they needed to get to the next destination, the guy screwed up the. They actually wrote it out on a piece of paper, and the pilot screwed up the number that you use for the conversion. So they ended up putting much less gas into the jet than they needed to get to their destination. So the jet ran out of fuel halfway. Jet fuel. They ran out of fuel more than halfway over there. It was called the Gimli glider. If you look that up, it's a pretty well documented air disaster in in Canada. Thankfully, no one was killed. The pilot just pure stroke of luck. The pilot happened to be very experienced with glider flight and unpowered flight, so he was able to, when you run out of fuel in an airplane, you don't just fall like a stone, right? It glides down as the weight and momentum allow it to retain enough speed to give lift to the wings. Especially as it starts coming down to the ground, right? You nose down to increase the speed, and that generates more lift. So he was able to glide the airplane to a old abandoned military airstrip and land on it. He also landed with no front wheel, no front nose gear, because the plane, when it ran out of fuel, also ran out of power. And it was one of those modern jetliners. I think it was a 787 Dreamliner. No, it wasn't. Sorry, no, it was not. Dreamliners came out much. This was, I don't remember. Yeah, it was in the 80s. The Dreamliner hadn't come out yet. But it was a modern kind of new airplane for that time period. So it had a lot of advanced electronics and computer systems, which were completely useless when the engines died. So, the pilot had like basic instruments, but also the transponder disappeared. And I remember, if you see this on Discovery Channel, has a thing called Mayday, which documents like air traffic accidents around the world, and like does dramatic reenactments of them. So they of course did. The pilot landed that plane with about I would say an equivalent amount of skill as Captain Sully with the Miracle on the Hudson, where he landed an airplane that had a twin engine failure on water without any fatalities. The Gimli glider took an airplane that was at cruising altitude and safely landed it with a twin engine failure. Yeah. Anyways, that's the changing from imperial to metric was not smooth, but thankfully, now we have systems in place to make sure that doesn't happen again. It's kind of funny when you hear because the flight came out of Quebec, and so they're talking to the mechanic, and the mechanic, of course, being francophone in Quebec, he is like, "Oh yeah, the pilot asked me for this amount of gasoline, and I put that gasoline in. You can check my logbook." Got the Quebec accent is come on, let's face it, the Quebec accent is is Canada's gift to the world. Let's face it. Anyways, this is the portion: Indian and lands reserved for Indians, copyrights, patents, bankruptcies, immigration, right, naturalization. This is the only reference to aliens in Canadian law that I've come across. Right, we just permanent residents, landed immigrants is usually the term we use. And again, it just goes to show you how much U.S. law shaped Canadian law in early days. Only we had added the Second Amendment. Oh well. And of course, this is the power of the criminal law, which is stated just plainly, right? And then we have the exclusive powers of provincial legislature. The ones that really apply to us, these are a lot of things. Public lands belonging to the province, the timber and wood thereon, provincial regulation. Public lands belonging to the province, most land in the province belongs to the province. Federal land typically is the Indian reservations mentioned above, and federal parks. So Banff National Park is a federal land, federal jurisdiction. And the province's laws have no. That's not true. Some of the province's laws has effect there, but only to the extent that they don't conflict with federal laws, and that is what's called inter. You saw that I didn't read it out, but I did kind of stop the screen on a consideration of interjurisdictional immunity. Reading the conclusion, very bottom of the document. That's what that principle. The fact that laws of competing jurisdictions, the jurisdiction to which the law validly applies shall take precedence over the law that of the other jurisdiction attempting to regulate it, to the extent that there is a conflict. But the rest of the law shall stand. And so the federal government doesn't establish a speed limit on highways within the federal land. The provincial law then applies. I think in theory, the federal government could possibly regulate speed limits on a highway entirely within federal land. I don't know why they would do that. That wouldn't make any sense, but I think theoretically they could. That'd be a tough one. I think the principle of interjurisdictional immunity would apply, and the province's general speed limit on all highways that are within the boundaries of the province would be superseded only to the extent that the speed limit would be different on the federal land, and then once you leave back, the provincial one is back in effect. That probably was not a good explanation of interjurisdictional. I would say, I took constitutional law in first year. That was an area the whole class struggled on. Even a prof struggled to like lecture us on it because it's a difficult area of law. Then there's another one too, parliamentary supremacy. Is that the right one? No, that's not the right name. Oh, great. Now I gotta look it up. I get distracted on these streams all the time. Oh, no, textbook. Right. All charter stuff. Order and good government. Come on, it's here somewhere. I'm derailing this only because it's, call it what you will. It is the fact that I can't remember the name of the other area of law that's related to interjurisdictional immunity. Paramountcy. That's what it is. There it is. Paramountcy doctrine and interjurisdictional immunity. Paramountcy. We'll pour a shot. I don't have a shot glass to actually measure. I'm just gonna do a sip. Sip. For forgetting what paramountcy is in relation to interjurisdictional immunity. Here. By the way, That is my bottle of Highland Park. I have said many times, 100 times on this channel, always have a bottle of Highland Park handy. I will finish that drink, don't worry. It's supper time right now, and I have not eaten yet while I'm shooting this video. So, I should have done this as a live stream. Man. Oh well, whatever. I'm not cutting any of it. Why? What? I did have that bad flub, and then of course I sneezed early. But whatever. I'm not gonna edit. One, because I'm lazy, but also just let it stand. Anyways, interjurisdictional in Paramount. Go back. We have an advanced constitutional class that will cover those topics in greater detail. A first-year constitutional law class just cannot do it justice. Fairly complex areas of law. Anyways, all of that is to say that I'm not sure I gave a good example of interjurisdictional immunity. In any case, it was considered in dissent, so there might be a little bit that you could use because the majority did not consider that doctrine. They had already found the law unconstitutional. They didn't have to apply the second test. I don't think in the dissent they applied the test either because they thought the argument from the province of Alberta was deficient. So, you can see the federal power, we're in the provincial power. And so you can see here, so this is like gambling and liquor license, right? Shop, saloon, tavern, auctioneer, and other licenses in order for municipal purposes. That's entirely within provincial jurisdiction. Municipal institutions, right? So, of course, the entirety of the Municipalities Act, municipal elections, all of that is the instrument of the province. The establishment, maintenance, management of hospitals, asylums, charities. I have no idea what this is. I should look that word up sometime. Local works and undertakings. You might remember that from the ruling. Oh, no, it's... Oh, whatever. We'll go back to it. Or we won't. No, we don't want to go. But anyways, local works and undertakings other than such as the following classes: lines of steam or other ships, railways, canals, telegraphs, and other works and undertakings connecting the province with any other or others of the provinces, or extending beyond the limits of the province. So, pipelines that cross provincial boundaries are federal jurisdiction, sort of. Yes, they are. All railways, whether inside a province or going through a province, are federal jurisdiction. Steamships, kind of outdated, but hey, I think it's outdated. And a project that is situated entirely within a province, but declared by Parliament to be for the general advantage of Canada or the advantage of two or more provinces. That would be considered like that would be like if you build something that is entirely within a province, but its benefit kind of exceeds the provincial boundary. I'd be remiss to think of a specific example, but anyways, that would fall under federal jurisdiction, the obvious reason. Provincial. But other than that, like things that are not in those lists are provincial undertakings. And so you can see where the intrusion on the provincial rights was. Solemnization of marriage in the province, property and civil rights. Very interesting to note that while criminal law is federal jurisdiction, the exercise of your property and civil rights are provincial jurisdiction. So, litigation, civil litigation, is regulated by the province. That's interesting. Same with property rights, regulated by the province. Only criminal law is entirely federal. In fact, it actually becomes a huge question of law when provinces create penalties under their regulatory schemes, and they create laws that may have quasi-criminal impacts. The Highway Traffic Safety Act is one of them. And so that one has, the regulation of highways has been, it's a result matter of law. That's definitely provincial jurisdiction. Interesting, because actually, a highway goes. Well, actually, the boundary of the highway, the provincial jurisdiction of the highway, ends at the provincial boundary. Even the Trans-Canada Highway, the jurisdiction over it is whatever province that portion of the highway is in. It's just a coincidence that it's designated Highway 1 in 3 provinces in a row, right? Manitoba, Saskatchewan, and actually 4 provinces. I think British Columbia also calls it Highway 1. When you get to Ontario, though, it turns into Highway 17, but it's the same road. So technically, the road kind of stops at the boundary and then extends over into the other province and becomes a new highway. I guess that is consistent. Highways definitely are, for the most part, the highways are definitely within provincial jurisdictions. I'm just trying to mentally reconcile that right now, and interesting to see what the law is on that. But that would be one of the ways that it could arrive at that conclusion, is that the highway designation, Saskatchewan Highway 1, ends at the Saskatchewan border. Even if the road continues, it becomes a different road. I guess for the 1 inch that the boundary exists for, that is federal jurisdiction. So don't commit a crime on that 1 inch of land. I don't know. I don't know if that actually anything. The administration of justice province. So the interesting part is that criminal law is federal jurisdiction, but the procedures of bringing someone to court for a criminal law code violation is provincial jurisdiction. So the courts, right, both civil and criminal jurisdiction, the courts are provincially regulated. And the imposition of punishment by fine, penalty, or forcing any province. That's where the quasi-criminal, right? There is a section that allows you to imprison someone for a quasi-criminal thing. It's not it's a regulatory matter. Wouldn't be criminal because of the division of powers. Anyways, there's this extra note here too, 92A, non-renewable natural resources, forestry resources, and energy. Each province, the legislature may exclusively make laws in relation to exploration for non-renewable natural resources, right? Oil and gas, fossil fuels, development, conservation, management of non-renewable natural resources, and forestry resources in the province. Notice that they're given distinctions. And development, conservation, management sites and facilities in a province for the generation and production of. So, with those divisions of powers, you can see where the Impact Assessment Act crossed into that provincial jurisdiction. Especially here, right, where you're seeing where there's a better way to build that project. That's entirely out of federal jurisdiction. They exclusively make laws in relation to development, conservation, and management. Right? So that law was ultra vires of Parliament by that portion alone. The other deficiency of this law was there was nothing here that said, hey, you may consider all of these, but only this one and this one shall be used to render the final decision. Because sometimes, right, if you're going to study if you're going to study the impact on any indigenous group, you might have to also consider all of these things. And that would be allowed as long as the final decision turns on this factor. But there's nothing in here that says that that's the requirement. And so therefore, these were considered to have been given equal weight consideration. And several of these are clearly outside of jurisdiction. Generally all matters of a merely local or private nature within a province. Right? Again, that's the language that you saw in the Supreme Court decision, and that's being, it's drawing directly from the Canadian Constitution. Well, that's gonna... Video was a lot longer than I thought it would be. I thought it would only take about 40 minutes, but I get sidetracked so often. So that's why these videos take. In any case, this is the review of the Supreme Court decision regarding the Impact Assessment Act, its unconstitutionality, and my closing thoughts on this. I foresee the Parliament going, the Trudeau government going back to Parliament, retooling the Impact Assessment Act to make it compliant with the deficiencies that the Supreme Court noted in the decision, and then pass it under the exact same thing. Nowhere in the Supreme Court decision did it say that the regulation of pollution, right, or Canada's obligation to fight climate change, according to the Trudeau government, impacted provincial jurisdiction. The court made no observation of such a thing, and maybe someday I'll go through the Greenhouse Gas Polluters Pricing Act and look at the, because I'm pretty sure it was POG that ruled the day on that one. I'd have to double check to be sure, but the court found that, yeah, it took judicial notice that climate change is a pressing, a matter of national concern and a pressing matter before Parliament, that it can retain jurisdiction to legislate on. So it found that the carbon tax forcefully imposed upon the provinces was constitutional. So that's why I think the Trudeau government's going to take this law, go back, retool it, and then make it, make... The good news is, by the sounds of it, even if the government retools it, the court had a problem with how it could use the overbreadth of effects within federal jurisdiction to shut down an otherwise valid project. So I think that might be the saving grace, that even if the government retools the law and comes back out with the... Because we know that the Trudeau government's intended purpose was to stifle oil and gas development and to add extra regulatory hurdles to ensure that fossil fuels couldn't come to market, because they drive climate change, according to the Liberal government. The fact that the Supreme Court has taken judicial notice of that fact, that it considers that fact to be of no controversy, is reality. Call it whatever you want, valid or invalid, it's reality. And so the laws that regulate from that point on, under that assumption, are all going to be valid, as long as they're valid in its entirety and other, when it comes to the other parts of our Constitution. Anyways, hope you found that informative. I hope for a better future, a change in government for Canada, because if the No More Pipelines Act is allowed to stand as good law, it especially that intersectional clause was just, there's such a better way to have said that, but obviously the Trudeau government wanted to make a statement with that clause. So, oh, I don't know. At the end of the day, law is law. We're going to get lost in it. Well, I hope you guys enjoyed. I'll catch you some other time, whenever that happens to be. Till then, stay frosty.